Welcome to the O'Connor Elder Law Channel. I'm your host, Melissa O'Connor. I'm a Florida-based elder law attorney who does estate planning, focusing on long-term care needs, commonly referred to as Medicaid planning, and I do probate, and I do it well. Today, I wanted to talk to you about home and community-based care for married couples when one spouse needs care and the other spouse does not. But before I do, I wanted to invite you to schedule a free strategy session with me at eldermeeting.com. Okay, so let's get into today's topic. I picked this topic because I recently had a call with the area for aging, for the Agency on Aging here in the county that I serve, and my client is a spouse of they're in a married couple, and one spouse needs home health based nursing care while her husband does not. And it just became super obvious that her level of care was such that if we did not get home health nurses in place, that she would have to move from the home because it was no longer safe for her to stay there into a nursing home care level provider. And so we did the application and a referral for community-based care because she was the ideal candidate for that. And we worked to make sure that the couple's income and assets could meet the requirements. And when we put in the application, they got the call, their intake call from the government. And they said, oh yeah, we can see that there's a health-based need, but and we see your income levels are perfectly fine, but as a couple you have way too much assets. The interviewer said that the couple was only allowed to have $3,000 assets to their name. And that simply is not the case. They were mistaken. $3,000 assets is if both people in the marriage, both the husband and wife, needed care, needed Medicaid. But there was only one applicant here. Only the wife was applying for care. And so the asset limits in that situation are $2,000 would have been for the applicant, the wife, and the non-applicant, the husband, he was allowed to maintain $130,380 combined assets. And that is in Medicaid, lingo, that's called the Community Spouse Resource Allowance. And he was able to have that much money in their joint bank accounts. And so we were able to make a call back to the assigned worker, the caseworker, and make an inquiry, and it was just a mistake. And they were gracious and said, oh, thank you so much, that they learn something new every day. And that's just, and it's great because that my client gets the care that she needs and her application is not held up in any way. But the point of the message is people make mistakes. Even those people who are processing your applications, they can make mistakes. They're working off spreadsheets and charts, and they could just be looking at the wrong column and misspeak, or otherwise you might be the first type of case with your fact pattern that they've stumbled upon during their time there at the agency in that job. And so it's an opportunity for them to learn too. And so the point of this message is to not be discouraged, to know that if your spouse needs care, that you do not have to be the community spouse, the person who is healthy and does not need Medicaid. They are allowed to, hold assets countable that would otherwise be countable jointly, as long as it's below the threshold. And that don't be afraid to invite a conversation and to just get clear as to the reason for your denial and what you can do to make sure that it was based properly. If this information has been helpful to you, I ask that you like and share with others. You feel free to schedule a free strategy session with me at eldermeeting.com. And again, thank you.